Thank you so much for that kind introduction, Sarah. Let me just share my screen. Is the screen visible?
Yes, sir. Yes. It is visible, very much visible.
Hello?
Yes, sir.
Your screen is visible, yes.
It is visible.
Yeah. First of all, thank you so much for this kind introduction. It's indeed a privilege and a pleasure to be associated with the University of Mysore and Professor Benjamin. Thank you so much for this kind invitation to this very important and relevant session about role of IP in the employment generation. I would also like to greet and thank Mr. Hashmi for inviting me to this, and my co-panelist Raghvendra sir, Srinvasalu sir, Dr. Roy, and Dr. Janal Gada. Thank you so much for that, making me part of this panel. I think this topic is very relevant in the present times, like Professor Benjamin mentioned, how these terms are no longer just abstract terms, but they're actually now very well rooted in the Indian ecosystem, and they are definitely having an impact on the not only the growth but the society at large. So I'll briefly take you through to my slides, and the index is right there in front of you. So I'll talk a little about the glance at the Indian economy, India's journey to the innovation sector, India's employment growth, overview of India's startup ecosystem, role of patent in generating employment, value of industrial design protection, employment impact of design protection, geographical indications, IP ownership, and employment and economic fallout of fakes. So we'll cover, how they impact positively as well as negatively to the society at large, including the generation of jobs or taking away jobs if they encourage counterfeit. So India is ranked at number 1 for lower middle income countries. So that's a pretty good sign that we are ranked number 1, but we are looking at moving to the different rank altogether. So the 2047 target set by PM Modi is indeed, to move towards a well-developed economy. And that is something we would strive at going to the 5 trillion economy. So these all indicate the initiatives from the government to not only it's for an all-round growth of different sectors and not limited to a particular sector there. And they are very much aware of the impact of IP on the society at large, including the employment generation. Uh, as far as the economy size, India holds the 5th position globally. We have one of the youngest youth population across the world, with approximately around 380 million young people living in India. We have more than 1.57 thousand startups, 1.57 lakh startups in India, and which number is growing on a daily basis. Which has resulted in a lot of policies, IP-centric policies for the startups, including the SIPP scheme, which has been mentioned earlier, which is actually a boon to the startups because they're able to file more applications. First of all, get more aware about IP rights, file those applications in India, and gradually take those applications outside India. So I think that we can actually see the growth of a country, and IP parameters are a very important parameter to see how the country is growing. For example, we are touching almost 600,000 trademark applications, more than 100,000 patent applications, and around 30,000 design applications. So over a period of last 7 to 8 years, we can see the numbers have actually grown at a very rapid speed. In fact, during COVID also, we saw that the growth was very much there, and the online filing of facilities at the IPO actually eased it and made it much easier for companies and startups to file even during COVID. On GDP growth, we are touching around 7% to 8.2 expected. And even otherwise, even 6 plus is a very good growth rate for India, and I'm sure it would be only getting better from here onwards. Innovation ranking, I think we all of us know how India has been growing through the ranks in the innovation index, and we are currently ranked at 39th position. So, like I mentioned about the innovation index, 39, and which actually score about the IP policies which the government has initiated over a period of time. We have the startup scheme, where the applicants have almost 50% reduction for filing fee for trademarks, 80% reduction for the filing fee for patents, and which has really encouraged the local entities, the startup entities, to file more. And it is not just limited to the startups. We have a scheme for MSME, where MSME gets a 50% reduction on fees, similar to the SFEP scheme. And in fact, after a trademark or a patent has been granted to an MSME, and they have not taken benefit of any other scheme, for example, they have not taken benefit of the startup scheme, they can actually look at reimbursement of the fee paid by them from the government. So they get around 10,000 back for the trademarks which have been granted. And if a patent has been granted abroad, you get 5 lakh rupees for each granted patent abroad. So that's a big incentive and initiative by the government to encourage R&D not only in India, but also for R&D to be protected outside India. And investment in R&D, I mean, it has been a regular feature in the budget. It has been the regular feature for all important companies, startups to, keep aside a certain amount for investment in the regular R&D. So it's a cyclical thing. The more you invest, the more returns you have, and the returns would encourage you to get into more R&D. And collaborative environment, like I mentioned, startups are also tying up with education institute, with government institutes, to ensure that there is an all-round growth, and it's not limited to a particular startup alone. Like we have seen companies now tying up with IITs or big institutes to outsource their research, or to have joint collaborative research and agreements, and which is quite similar to the US universities, which have been, over a period of time, we can see, have invested a lot into providing industry-specific outputs and research. And we can see that big change coming into the Indian IP ecosystem, where startups, companies, and the educational institutes are working together to find better results, to find R&D or innovation, which can help all. And so that is about the index. And coming to the employment growth, and I think Professor Benjamin also mentioned, so we have seen that the growth has been there on the employment front, definitely. It is across domains. It is not limited to a particular sector. We have like EV is growing big. We have medtech growing big. We have edutech growing big, and we have medical devices growing big. So it's across domain. We can see a lot of impetus from the companies, and I think the natural corollary here is that as we grow, the companies grow. They need more manpower, and that is leading to more employment generation and upskilling of many people. So I think upskilling is again very relevant, that students who are coming out of colleges and schools, they are aware of that the practical side of a work firm is very important. They need to know that how the theory they have read at colleges has to be applied when they have that experience at the firm's hands-on experience at the companies. And so that is, I think, quite relevant for them as well as for the companies, because they're able to upskill and have graduates who are more aligned or more practical approach into working, and who can be easily hired of the school. So I think that's a very synergistic relationship for the companies and the institutes to provide that practical approach, practical growth, practical internships to the students to make them more ready for industry, and at the same time for the industry to provide that basic forum for the students to be industry ready. So I think that's a good synergy to have, and which is growing further. And job creation, as you can see, almost 170 million jobs have been created since 2016-17 to 22-23. So that's a huge number, but I believe that's the best is yet to come. We would expect more work being generated, at, especially for the IP-centric entities, which would definitely result into more job creation, direct as well as indirect job creation. So ecosystem, the startup ecosystem in India has been growing. Almost 1.57 lakh certificates have been issued by the TPIIT, and many of these have grown really big, whereas others are still working to see how they can get better. So we have many unicorns driving innovation, and leading sector with 2.10 lakh jobs is the IT one. And professional and commercial services, we see a significant job creation of almost 100,000 jobs there. So it's not just the IT, but also other services there. Healthcare, second highest job creation with 1.51 lakh jobs. And like I said, over 17.28 lakh uh, direct jobs created under the ecosystem, the startup ecosystem. So just to give an idea about how startups are doing and how the IP generation by them, we have seen a growth, and which is an important parameter for to see the growth of an economy. We can see that 2019-20 there were almost 1,600 applications, which have grown till last year to almost 2,500 applications. So there's a steady growth we have seen, and foreign startups are much lesser, but Indian startups have been really going with blazing guns. But I expect more work to flow as more awareness comes through for startups, and they recognize the importance of patents and other IP rights. Uh, so startup is driving growth story on a number of fronts. You can see that hiring index in March 2024, the parameter 276, hiring index in April 2024 almost 300, year on year hiring increase of 9%. So that is only coming from startups itself, and startup growth of almost 37%. And whereas the startups are contributing to almost 14% of the job creation, and fresher job allocation is almost 53%. So startups seem to be preferring a lot of freshers, and a lot of freshers are joining startups, and which is indeed a welcome change there. Uh, Startup and IP, like I mentioned about the scheme and the benefits from the SIPPs, where it's not just the discount on the fees, almost 80% for patents and 50% for trademarks, or 75% for designs, but it is also the expedited grant of patents, which is there for startups. So actually, you can have a patent granted, and we have had very good such case studies where patents have been granted within 6 to 12 months, which is almost as good as any other developed country, if not better. So the grant of the patents at such a fast speed encourages investment into the startups, and the more investment you get into the startups, it'll be leading to more job creation. So that the IP itself, by able to grant those patents much faster, would lead to more work generation for the the companies itself and for the economy as a whole. So the global patent valuation service market is reaching around 70 billion this year, and this is a big indicator to see that how the valuation for patents is changing and increasing, and 70% of startups depend on IP protection. So there are pluses and minuses here. Many startups, at times, they're not aware of the IP right, but once they burn their fingers, they do realize the importance, and they strive to file patent applications to protect their innovations, to file the designs and trademarks, and be able to monetize those IP rights in a much better way, because when they go for any funding to any VC capitalist, venture capitalist, or uh, other investment HNIs, they would first look at the IP portfolio. How strong is the IP portfolio? Is that innovation protectable? How many people, how many competitors are in those domains? And what kind of fences have you built to prevent the competitors to come into that particular domain? So that kind of an IP audit is there, and the investors would look at that IP audit to understand the strength and the weakness of the startup. And I think that is important for the startup to understand that also, and file applications as and when they innovate, and not burn their hands like many startups did earlier. From a business perspective, I think approximately 80% of major businesses consider IP as crucial to growth. I think that is, again, which really talks about the awareness being much better than what it used to be. People are aware that you can actually use IP as a business tool. It's not like mentioned earlier by Mr. Hashmi, that it's not an abstract term, but it is actually a business tool which can be utilized by businesses to make up, draw up fences to ensure that the competitors don't come through, they don't have that kind of right or statutory or common law right to come into the domain of the startup. So that domain is protected for the startup using IP, and you have a monopoly of 20 years to actually use that patent for its life. And obviously, like any other property, like any other IP, it can be licensed to different entities. It can be assigned or sold to different entities. So it's good to see that almost 80% of major businesses consider IP as very crucial for growth. So that is, I think, a very good feel for the industry, feel for the society as such. Investment focus. So investors are allocating significant funds towards innovation driven by patents. So like I said earlier, so they are looking at innovations. They are looking there because they are getting pitched by so many entities, so many startups and students. So it's difficult for them to analyze all. But when you are pitching to them and telling them that, okay, we have filed this patents and trademarks and designs, so they're aware, first of all, that you're IP savvy. Secondly, that you're able to build that fence to keep the competition out. And so that makes it much easier for them to take a decision to invest uh, in that startup. And obviously, investment would result in more R&D, more protection, and more exclusivity for the startup to build on and create not only a name, but also a very positive bank balance for the startups themselves. So, like I said, investors love IP, and they would have to have proper IP audits done, information about the weakness, strength of the IP portfolio, and they seek IP-backed solutions as proof of originality and substance. So that is the best way to tell that a patent has been granted, which means that it was something really significant, significantly different from the existing art, and also to which implies that there is a fence to keep the competition out, and ensure more regular royalty for the startup. So, which is a big consideration for them to invest into a company. Uh, so VCs prefer startups with IP because it increases long-term valuation. So obviously, as the company grows, the valuation of the company also keeps growing with the kind of work they're doing, with the kind of IP protection they have done. And so the investors would also look at a long-term growth strategy for the entity, which would imply also the valuations have to go on increasing with time. Global expansion. So IP ownership facilitates global expansion, licensing opportunities, and strategic partnerships. So it's not just limited to the mother country, but also looking at beyond the borders, where it would lead to expanding into domains which can be protected, which can be protected under the patent regime, so that no other competitor can come into that. So we have the benefit of the PCT to enter into different countries, or a national phase application, or a convention application to be filed to get into different countries. So global expansion definitely is the first way to using IP for global expansion. And I think we need to keep in mind, especially for patents and designs, that there's a novelty period, novelty criteria, and they need to be filed in those countries outside India in a limited time. So you have to file that application if it's a priority application for design in 6 months, and for patent it's 12 months. So that expansion is there, but you need to be mindful of the deadlines which are associated in taking the application outside. Like I said, PCT is there. So PCT, if you file PCT within the 12-month period, you have another 18 months or 19 months, depending on the country, to get into that country. So that also helps the PCT filing, because that will give you around 30 to 35 months to decide. It kind of gives enough time for the startups to understand if the project or the innovation they're working on is actually economically viable or not. And rather than spending more money to get into different countries, they would have more reality check to understand what is there and what is missing, and how to bridge the gap. Funding raise. So Indian deep tech startups with significant IP have raised more than 994 million US dollars across 284 rounds in 2024. So I think the numbers speak to themselves, that the IP has been growing. The IP raised by startups who are focused on IP, you can see that it has been growing. And similarly, the 47 IP-led startups have secured $220 million funding across 47 deals. So it's really good to see these kind of numbers for Indian startups, Indian entities to growing basis their IP. So that's a big plus there. I think this slide is just to show about the employment growth trends, and how employment has also been growing in India across sectors, and we can see the impact of IP also on that. So is job and growth linked? So you can see the real NPHCE there, and the growth percentage. So India's growth has been driven by consumption, which is closely tied to employment. A rise in consumption implies that employment generation is occurring, as consumption would decline if employment were predominantly in unpaid or low wage jobs. So it's a reflection of the state of the employment status also in India, because any rise in consumption would be directly related to the employment generation. So if you are employed, you are paid good wages, you would buy more, and the consumption will go up. So that is the very easy connect there, that as the base, the size of number of people employed increases, uh, there will be further the growth in the market also. Economic survey, if you refer to that now, low employment, employment is low, around 3.2% in 22-23. Youth unemployment dropped. So youth unemployment has dropped from about 18% to 10%. So that's a big change to see for the youth were underemployed or unemployed, but that number is going down. Factory growth, big factories, 100 plus workers are growing and hiring more. Formal job creation, Formal job registration through the EPFO have doubled in recent years, and shifting employment where jobs are gradually shifting to manufacturing and services. Women in workforce has been increasing. More women are joining the workforce, be it on the services side or even the products side. Another factor is the rising rural wages. Wages in rural areas are rising steadily, which is again, increasing the consumption, and consumption increase would lead to, for the companies to produce more, which would lead to employment generation. So I thought I'll touch upon the filing trends. Like I already mentioned, we're touching around 100,000 applications. We have touched. This is 24, so we already touched 100,000 applications, patent applications, and trademark. I think we're expecting to touch around 600,000 applications in the current financial year, and many of these applicants. And I think the important point I would want to put here is that on the patent side, almost 52% is local filing. That is, the entities based in India are the applicants. So, which is a first time for India ever that the patents filed by Indians is more than patents filed from abroad. So that's a big commendable shift we have seen. And I think trademark is a totally different animal there. Of almost like the numbers we see, almost 98% is local filing, and we can see the change. The Indian entities, and trademark is always the first point of contact for the customers. So even if there is no high-end R&D being done by applicants, the design and the trademark element are the first, and we can see in the numbers that the entities are filing a lot of trademarks, a lot of applications from the local industry, 98% being from the local industry, and you're getting the MSME benefit, you're getting the startup benefit, and the fuel is also, I think, from the e-commerce. We have seen that e-commerce, how it has grown over a period of time, is making many more entrepreneurs, and entrepreneurs who are looking at protecting those trademarks so that they can have an edge over other people and not just sell goods without any trademarks. So that trademarks is, I think, the first point of contact, yet a very important IP for the growing companies who are, getting their first taste of IP. It is trademark. So once they understand trademarks, probably then they could shift to design and then eventually to patents. So role of patents in generating employment. I think I think first and foremost is the patent monopoly of 20 years. So that is an exclusive right to the patentee to have that monopoly, which encourages them. Obviously, once you have a monopoly, you are able to sell. You are the only one selling in the market, and which gives them a very good advantage, and then which also encourages them to put more money in R&D. So there is an increased R&D cost factored into their growth, and so more R&D means more products coming out, which will have more time period as a monopoly, and therefore the cycle goes in a very positive side, where it's increasing R&D means increasing output of IP, and IP means more revenue to put back into R&D. So it's a good cycle to have, that you were able to generate more IP through increased spending on R&D. Domestic production protection under industries thrive without overshadowing. So you get the protection in India. Like I said, you have a monopoly. You're able to stop the competition and able to make that border, the fence around your innovation. Startup growth, getting the benefit of the startup scheme, getting the benefit of for Indian entities to file outside. And once you have those, the monopolies, again, it will lead to more R&D spend and continual spiraling growth there. Economic growth, many new innovation would lead to expansion of the domains. They're not limited to the traditional domains, but many new age sectors and domains are coming up, new industries, and a lot of job creation in not just the traditional industries, but across domains. So I think that is also a big result of IP savvy company, IP savvy economy, that you're looking at growth of different sectors. I think recently the income tax department also added a number of occupations or professions to their form, which showed that the money or the revenue being generated is not limited to only the traditional industries. So even like influencers and all, or other new age professions, they are also looking at protecting their innovations through IP, and which further fuels the growth, the economic growth. So then we have reduced dependency on foreign investment or foreign innovation, because obviously the innovation which is done in India is more apt for India, and it can be easily used, it can be easily replicated, and easy for the patentee to earn more revenue, and which also leads to reduced dependency on foreign technology at times. You don't need to, obviously there will be very cutting edge technology which would be required from foreign companies, but otherwise you would see a reduced dependency on foreign entities for basic innovation. So that innovation is being generated and being protected by the local Indian entities. And so therefore it incentivizes local innovation, and like I said, the cycle continues. Innovation, IP generation is increased profits and coming back to R&D there. So after patents, I think the impact of design protection, you can see the key roles created by design IP. I have been teaching at the MP School of Design and DIT Dehradun, and we've seen the designers being more aware of IP, and they're getting more aware that they protect their IP. It's a monopoly, and obviously when we are talking about patent and design, design is more or less the first point of contact after trademarks, and it can be easily protected. You have like 6 to 12 months, you can get it protected vis-a-vis patents, which may take longer if it's not a startup, and it's an easy, quick ride, not that expensive, and so therefore they have a monopoly, they have a right, which would lead them to have a more employment being generated because they are creating more revenue. Creative design, so product designers and 3D models are bring concepts to life. So you are expanding the domain of the professions related to design. So it's not limited to the normal designs, but you have people or the professions which are ancillary to the main design, where we have seen growth and a lot of employment opportunities. Engineering and development, so prototype engineers turn designs into functional models. So you can see another domain, another aspect of employment generation from the increase of design filings. And production and operations, manufacturing and tooling teams, scale innovation designs, and startups increasingly protect designs early, attracting investment and fostering teamwork. So, like I said, that's one of the easiest IP rights to have, and I think startups should be looking very, very uh, importantly at design rights. Normally, it is a very underrated and right which is not given its due respect. And I think in an economy like India, design would be much faster and more relevant than patents. I'm not saying patent is not, but certain key industries patent would be. But for most of the innovation, I think design would be a very apt right to have in a very short period of time at a very low cost. Geographical indications are also very important in generation of employment. I mean, though normally you wouldn't expect, but it is, because the registered GIs, I think we have around 658 GIs, with filings increased over 380% in the last 5 to 6 years. And when the GIs are protected, you have examples of handicraft and handlooms, agro-based and traditional food products. So they kind of protect the local area. So GI would, and you would encourage more people in that area to, to initiate employment related to that GI. And once it is protected, it would also not only give employment to the local generation and local people there, but also encourage more investment into those particular GIs because the GI itself is protected. So I think it's a big incentive for GI holders to look at employment as a byproduct of growth there. And the more we grow, the more people will be employed to for bettering their targets there. So some of the GI-linked employment generation schemes, like rural and women-centric empowerment and specialized jobs for artisans, weavers, and farmers in rural areas. GI recognition empowers women through higher incomes and social recognition for their traditional skills and products. Significant economic impact examples. So Kerala GI banana varieties fetch 50% higher price than non-GI alternatives and directly benefited local growers, which would encourage them to file more. And the more they file, more people they would need for that particular industry. So Channapatna Toys Karnataka GI registration in 2004 transformed the region into a recognized craft hub, a toy town, securing livelihoods for thousands of artisans. Then we have Nagpur Orange GI protection led to premium positioner and doubling farmers' involvement, boosting rural employment. So we can see from number of examples where GI has been used in a very positive manner to sell the product at a premium and higher prices and higher revenue and profit would indeed make the GI holder to expand their businesses, which would lead to expansion of employment generation also. Cultural preservation and livelihoods. I think that's very important from the cultural perspective that GIs help in preserving the cultural heritage we have and also the livelihoods of people, artisans who have been involved in those particular trades and some GI for more than 100 years. We have people who have been doing that work, and if GI is not protected, that whole class of workers could get eradicated. They wouldn't find those kind of jobs, and they would eventually move out of that domain into something else. But because of the protection of GIs, the artisans' jobs are preserved. They get a higher revenue, and which kind of helps them to retain the jobs and probably increase the workforce to be able to supply that kind of numbers to the market. Coming to the end now. So IP ownership and firm performance, I think according to the EPO and EYPO report of 2025, intellectual property ownership significantly boosts the firm's performance. So if it is an IP owning firm, then we expect around 23.8% higher revenue per employee compared to non-IP firms. So I think that number itself speaks about that if you are an IP-centric, IP-savvy firm, and you have invested in protecting your IP, invested in monetizing that IP, you would have a return revenue of almost 23% per employee. These firms, that is the IP firms, IP-savvy entities, also pay higher average wages to their employees, so almost 22% higher wages. Again, because it's coming, they are able to generate, they're able to have a monopoly, they're able to generate more revenues because of the monopoly they have because of IP, which would lead to more revenue means more people involved, and those people also being kept at higher wages than the traditional non-IP entities. So that's good to see that the IP companies offer higher wages there. And 44% SME revenue boost. So small and medium-sized enterprises with IP see significantly higher revenue per employee. So they see the higher revenue, and the growth is quite visible with number of examples there. You can see that IP and employment generation has a very good connect, and it is being increased. Uh, so it's not just limited to the shop floor or the artisans, but also the legal and HR implications of IP active companies. Uh, Influences are an organization's legal framework and human resources strategies. So you also have better, the HR departments, the legal departments of the companies, which means more IP work generation there. So robust IP contracts, implement formal contracts with clear IP assignment clauses to secure ownership, innovation linked compensation, develop compensation models tied to innovation and IP outcomes, reflecting higher wage premiums for skilled talent. So, if you're a better talent, and like we saw in the previous slide, you would be offered a premium over the normal wage of a person who's not an IP savvy or looking at a non IP entity. And because of these so many factors, the expansion of roles, expansion on the monetary side, better skills, upskilling of the workers, and better wages, you would lead to enhanced employee retention for these entities. So it fosters strong employee retention through a powerful brand entity and steady growth driven by protected intellectual property assets. So I mean, you can see it goes beyond just making money for the applicant, for the right holder, but to the employment generation, direct and indirect, and also for other, like we see, enhanced employee retention. Uh, a negative before I end actually. So it is not that it is only positive, but we see that if it is not an IP savvy company, then we see a lot of job losses. Because they would employ people because it's a counterfeit or a pirater. They would have people underpay, undercut, at times not even pay them, and they could lose their jobs anytime. So there's no guarantee of a job on a long-term basis, right? Then reduce investment. So these are all pirates or the bad actors. So they're not investing in not only the machinery but also in the HR, in the legal, in the HR resources they have. And obviously, we have the losses of for the taxes for the government. We have losses for the society because these products could be dangerous, may not be fit for human consumption. So those issues can also come up, which can lead to higher cost for the society because there are more fakes in the market there. And let's see what the numbers say. I could probably try to fresh faster. So China, Hong Kong, Turkey, we see a lot of fakes there. EU import of fakes, almost 99 billion euro, which is 4.7% of the imports from rest of the world, fakes. And top categories of fakes are clothing, footwear, and accessories. And could skip this. So counterfeiting and loss of jobs, like I told you, I mean, there's a huge loss of jobs or underpayment or underutilization of the human resources there. So piracy economy is almost 22,000 crores, which is the value of India's entertainment and media piracy economy in 23. GST potential loss to the government of almost 4,300 crores is due to the piracy, and almost 5 million jobs are lost due to illicit trade, affecting approximately 25 million people globally. And tax losses, 58,000 crores suffered by the government due to illicit trade in the five key Indian industries, as per the Cascade report. So therefore, these figures actually underscore the urgent need for robust IP enforcement to safeguard legitimate economic activities and protect livelihood. So it's very critical that IP awareness increased and people move away from using third parties IP to creating their own IP and actually growing with that. Counterfeit linked workforce challenges, informal employment, limited development, and workforce instability there, which I've already talked about. And I think best practices, this is probably my last slide now. So strategic IP integration align IP initiatives directly with product development and overall business strategy to maximize the competitive advantage. Regular IP audits, I think, is a must to understand, what IP the company is sitting on, what can be utilized, what cannot be utilized, can let go, or can be sold, licensed, and at least monetized in some manner. I think employee IP training is also important from a perspective for the employees uh, are educated on IP protection and confidentiality best practices to safeguard the proprietary information and innovations of the company. So they're aware that they're working on a project which is not to be made public. They need to respect that and also help the company monetize and identify IP assets suitable for licensing and franchising. Like I said, many assets you could be not using or you could be using, but not to the extent which can be used. And you could look at licensing or franchising those assets in India or in other countries where IP has been protected there. So I think with that, I would end my session. I'm so sorry for overshooting the time provided, but I hope it was relevant and useful for the listeners here. Thank you so much.
Thank you, sir. Thank you so
Thank you
much,
so
sir,
much,
for
sir,
your
for your
rich
rich
enlightening.
enlightening.
Now we
Now
shall
we shall
move to
move to
our
our
guest of
guest of
honor.
honor.
I
I
request the
request
host
the
team,
host team,
Ms. Sara
Ms. Sara
Benjamin,
Benjamin,
to
to
introduce
introduce
Dr.
Dr.
Raghuvinder,
Raghuvinder,
sir,
Senior Consultant, IPR and former Joint Secretary, Ministry of Commerce and Industry, Government of India. Sara, you may proceed.
It is a great honor to introduce our esteemed speaker, Dr. G.R. Raghavendra, currently serving as Senior Consultant IPR in the Department for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, Government of India. Dr. Raghavendra is respected expert in intellectual property rights, international treaties, and competition law, with over 3 decades of distinguished public service. A retired civil servant from the Central Secretariat Service batch of 1988, he has held several critical leadership positions in the Government of India. Most notably, he served as Joint Secretary in the Department of Justice, Ministry of Law and Justice, where he also led the National Mission for Justice Delivery and Legal Reforms. His work was instrumental in advancing ease of doing business reforms, particularly under the enforcing contracts parameter and the implementation of the e-courts project. Prior to this, Dr. Raghavendra served as Joint Secretary in the Department of Promotion of Industry and Internal Trade, contributing significantly to India's free trade agreement negotiations and the Regional Comprehensive Economic Partnership. His vast policy experience also includes the intersection of IPR with emerging technologies and global trade. As former Registrar of Copyrights, he played a pivotal role in shaping India's copyright regime. His efforts were central to the enactment of the Copyright Amendment Act 2012 and the Copyright Rules 2013, which modernized India's copyright framework in alignment with international norms. Dr. Raghavendra's commitment to legal and institutional reform, his leadership in IPR policy, and his deep understanding of global legal frameworks continue to shape India's position in the international IPR landscape. We are privileged to have him with us today. Please join me in extending a warm welcome to Dr. G.R. Raghavendra, sir.
Yeah, thank you very much. Vande Mataram. Good afternoon to all of you. I would like to thank Professor Dr. M.S. Benjamin, uh, Dean Faculty of Law and Chairman, um, Department of Studies in Law, University of Mysuru. And also, I would like to uh, thank my friends, Professor M.S. Srinivasulu, and also Professor Pondaya and other distinguished persons, and also Mr. Vikrant Rana, the advocate from New Delhi, and other distinguished faculty members attending this seminar, and also the more than 100 participants attending this very important international webinar on the role of intellectual property in employment generation. So I've been asked to discuss the most important policy in the IPR, that is IPR in India, recent developments, reforms, and global compliance. And you're all aware that the most important policy initiative was taken by government of India in 2016 by introducing National Intellectual Property Rights Policy, that National IPR Policy. It was adopted in 2016, and thanks to the goddess Saraswati, who is the goddess behind the entire innovation and creation of other intellectual property rights. She put me in the role of convening those meetings and the work related to constitution of the body which drafted the IPR policy. So basically, the policy aims to create creative India and innovative India. That is the motto, and it is about the promoting awareness, stimulating the generation of intellectual property rights in India, strengthening the legal frameworks, and also improving the management, administration, importantly the enforcement, which Mr. Rana was mentioning about enforcement of IPR in India. So, for awareness and promotion, the government created a special cell called the Cell for Promotion of Intellectual Property Rights, CPAM, and Management. It is working in the very department for promotion of industrial internet, DPIIT in the Ministry of Commerce and Industry, and it has been doing good work, and also the enforcement kits it has brought out with the uh, mm, helping the enforcement, various enforcement agencies. It is maybe the state police or the customs authorities, other bodies involved in the enforcement of IP. That is one of the important contributions of the CPAM in this. And then coming to the promoting the generation of IPRs, stimulate the creation of new intellectual property rights by fostering innovation and creativity. I know if you see the entire history of the almost now the 9 years, how India got transformed once this national IP policy was released. If you see the figures, of the global innovation index, the figures of the India's ranking in the global innovation index right now in 2024 report, and in 2014, the entire period of 10 years, in 2014, India's rank in a global innovation index was 81, almost pathetic if you compare with the most of the key countries in the IP. And once this policy came, various steps have been taken to promote innovation and creativity. Yeah, you see the ranking now. India is 41st rank in the world in the global innovation index, and India is in top 10 countries in a patent filing. If you see the patent filing, India stands sixth in the ranking. And recently we have crossed the 1 lakh mark in the grant of patents, and that is the market change has taken place in the recent times. And another important aspect, if you look at the trademarks, a trademark, we are in the fourth position of trademark applications. And then we have done some innovation also there. You know, everyone is talking about artificial intelligence. In 2018, government of India came out with the strategy, the AI policy, under the leadership of Niti Aayog. Niti Aayog released the book, its study, National Artificial Intelligence Strategy. A strategy says that all the sectors have to work in a coordinated and collaborative way. So using now should not be working in a silos. So using this new technology, artificial intelligence, AI algorithms, and machine learning, Government of India has introduced the AI ML search for the trademark. It was launched by Honorable Minister Sri Goyal, Piyush Goyal ji, early this year in the March or April, and this is the best of the best use of technologies in IP administration and IP filing that India has produced. And another aspect of this IP policy is making all Indian laws in compliance with the international treaties. So, if you go by the industrial property rights, if you look at the patent laws, patent law was introduced in 1970, that legislation, replacing the colonial law. Before that, also, there was a patent act. But before 1970, the patent law introduced by the British, which continued even after the independence, that was catering to the needs of the British innovation, British manufacturing. So when India got independence, we did not have medicines and vaccines and medical equipment, and because all these things were manufactured abroad, only initial stages such manufacturing commenced. Thanks to Tata's and Birla's and few other companies. But there was an urgent need to improve the access to medicine and make this access to medicine more affordable. But at the time, the current patent law did not allow that. So Indian government, the then Indian government appointed two committees. One is the Take Chand committee and second one is the INR committee. Both gave a recommendation to government how to improve the patent system, especially focusing on promoting the Indian generic industry. Manufacturing biosimilar medicines which are therapeutically similar and also uh, affordable medicine, accessible and affordable medicine. But that India dropped the product patent protection, which was introduced by British in 1970 Act, introduced only the process patent that facilitated growth of the biosimilar and generic industry in India. You see all Dr. Reddy's, Nacto Pharma, Bharat Biotech, or Ranbaxy, you take a number of companies, generic companies which started manufacturing. India has become a key contributor. Almost 60% of world's biosimilar medicine is produced and supplied by India. If you remember, COVID pandemic happened, entire world was talking about India being a as calling India a pharmacy of the world. But that was only the revalidation or reinforcement of what we are already achieved before COVID pandemic. I know we could give countries like USA, which is yesterday only they imposed 25% tariff on Indian um, goods, they could not survive without Indian small medicine called paracetamol. India exported this paracetamol to them, and the innovation is such Indian innovation. Of course, we took one voluntary license now from AstraZeneca, Oxford, to manufacture the biosimilar medicine Covishield, and our own innovation in the Bharat Biotech Hyderabad that stimulated uh, that innovation stimulated introduction of
UC the
vaccine,
last one, Dr.
which
Chondayan
is
has joined.
a dead virus kind of vaccine. And the WHO clearly mentioned that when new mutated COVID virus varieties came, and the Indian vaccine was resistant to the even a new mutated virus COVID virus varieties. So this kind of innovation we did, and and very proud of that innovation. So how these laws are protecting the these kind of innovation and generation uh, of IP in India. If you see that Indian laws, if you take since I'm talking about the Indian Patent Act 1970, it's in total compliance with the international IP system, whether it's the treaties and especially the TRIPS agreement. Is a part of one of the bouquet of agreements of the multilateral agreement of the uh, World Trade Organization. And here, the objectives in Article 7 and the principles in Article 8 clearly mention about the balancing of right holders and public interest. This is what our Indian IP laws talk about. And while the protection of and enforcement of IP should happen in such a way that it contributes to the promotion of technological innovation and technology transfer. That's the main principle of TRIPS, which has been incorporated in our Patent Act. Transfer and dissemination of technology should not be a problem because you are protecting and enforcing intellectual property rights. So if, any protection and enforcement should happen to the mutual advantage of the creators and manufacturers of these products in which IP is embedded, uh, and also the users of technological knowledge like you and me, the public interest. So the protection enforcement should be in a manner that is conducive to the socio-economic welfare of the country. So balancing the rights and obligations. So what is the main issue here? The access to information, access to knowledge, and also access to affordable medicines to promote and protect the public health and nutrition. So we have woven our legal tools in the Patent Act uh, based on these principles. So, for example, recently there was a case of issue you must have heard, various pharma companies mentioning about the evergreening of patents. So there is a section 3D introduced, and that will not allow evergreening of patents or patent ticketing in India. So patent tickets are the large number of patents. What happens? One patent introduced that multinational pharma company, they try to introduce overlapping patents with unclear boundaries, particularly the that medicine, so that these incremental innovations and overlapping patents become a ticket kind of thing. And here what happens, the term of patent is extended instead of 20 years. So this will block the biosimilar generic industry to introduce affordable, cheaper medicine. That medicine which is biosimilar and therapeutically equivalent to the patented product. And 3D basically says that mere discovery of a new form of a known medicine substance do not result in efficacy of this substance, so it's not patentable. So evergreening is not patentable. One best example which Supreme Court has, when the matter went to the Supreme Court, whether 3D is legal or not, there was a Novartis application for patenting a drug called Gleevec. Is a beta crystalline form of the imatinib mesylate. This drug is meant for the colon cancer, and the patent assistant controller patents, he rejected the patentability and because lack of novelty and inventive step in this in 2006. And this Novartis company went to Supreme Court finally, and then Supreme Court clearly interpreted the efficacy word used in the 3D. Lack of efficacy means there should be therapeutic efficacy, and also the how bioavailability improves the therapeutic efficiency in these innovative drugs. So there is a lack of innovation, lack of novelty, uh, and lack of invention in this innovative drugs. So Supreme Court clearly
No problem. It is from this side. It does not have internet or something. Speaking from surface. Milan, see the screen.
own not their governments, and these developed countries created a lot of hullabaloo about the way the TRIPS is being implemented, developing and least developing countries like India and other countries. And in a TRIPS Council, a lot of problem happened. So finally, in 2001, the
Yeah, it's
commerce
fine.
ministers of the TRIPS members,
You just push a little
they
more.
held a conference in
No.
Doha.
Yeah.
They came out with a declaration called, famously called Doha
Yeah, it's fine.
Declaration.
Fine.
In this declaration, they reinforce and reaffirm the principles and objectives of the TRIPS in Article 7 and 8, and then clearly mention that the TRIPS flexibilities are the legal tools which gives an option to tailor the national patent legislation by these countries uh, to promote the public health. So TRIPS provision should not and does not come in the way of introduction of those kind of public health oriented provisions. Using the TRIPS flexibility is allowed for the developing and least developed countries. So Doha Declaration has become an important announcement by the uh, WTO, and finally it was confirmed by the TRIPS Council after a couple of years. So India, a country like India, benefited, and using those TRIPS flexibilities, not going the way the developed countries introduce the TRIPS plus interpretation to allow data exclusivity or to allow evergreening or to allow the patent linkage. So these are the TRIPS plus elements India do not recognize. Even in the bilateral free trade negotiations, we do not allow. If you have seen the news that very recently India has concluded free trade agreement with the you know, EFTA countries, Europe, this Switzerland, Sweden, Norway, and Denmark, and we have not agreed to these elements. And the other day, Honorable Prime Minister visited UK, and there was a signing of agreement between UK and India, the free trade agreement called um, Comprehensive Economic uh, Cooperation Agreement. And in this, a few critics started a selective interpretation saying that no, it's going to preferably it's going to promote only voluntary licensing, and that may affect the India's capacity to grant compulsory license. No, it's wrong. It's a wrong interpretation. If you see that India mm, follows the TRIPS agreement, Article 31 empowers India to grant a compulsory license. Indian Patent Act provisions, Section 84 to 92, clearly written to facilitate compulsory licensing in India. And Article 30 of the TRIPS, Article 31 of the TRIPS clearly support the way India has introduced the compulsory licensing provisions, Section 84 to 92. And Here, what happened? One bear, sorry, it is a one case reminds me of the compulsory licensing. Uh, that is the famous case of Nactoforma case, the Bayer Corporation's medicine against granting a compulsory license to Nactoforma. Again, it's a Hyderabad-based generic medicine company, and it is against the Bayer's Nexavar sorafenib tosylate. It's a colon cancer medicine. The cost of the medicine, 60 tablets suggested to 1 month, two doses per day, is 60 tablet per month. The cost of this drug is 2,80,000 rupees per month. Imagine how a common man can afford such an expensive drug, life-saving drug for such a dangerous disease called colon cancer. So technically, it's not working. So the Section 84 clearly mentions about the reasonable requirements for the uh, granting of this compulsory license, and whether the license is the patent granted is working in India, and India follows basically a balanced approach, and this compulsory license were granted as per the completely WTO TRIPS principle, and that uh, and also assessing the actual manufacturing capacity and the facilities available within Acto Pharma, and also whether they have the necessary expertise uh, to manufacture this. Even these guys have manufactured this colon cancer medicine, Nexavar, even without technology transfer. I mean, you can imagine uh, the capacity, manufacturing capacity of Indian generic medicine companies. So it has been granted because the it is patent has not worked. That is the main condition here for granting the compulsory license. And obviously, these guys went to Supreme Court, and judgment came in 2012, and supporting the Indian government decision to grant compulsory license. And only thing is, some compensation is given to the patentee, and India followed the UNDP guidelines of 6% of revenues earned from this earned by the Nacto Pharma by selling these medicines profits, and And only thing, the small change made by Supreme Court in its judgment, upholding the compulsory licenses, it increased the compensation to 6 to 8%. Only the 2% increase they have made. So that is the strongest method India follows in implementing the international laws, because Indian Patent Act is in total harmony uh, with the international patent system. Like India is a member of TRIPS, as already mentioned you. India is a member of Paris Convention, but India is also a member of Budapest Treaty, where microorganisms the genetic material and microorganism compulsory deposit takes place there. And we have two such depositories, one in Chandigarh and another in Madhya Pradesh. And India is not a member of the important Strasbourg Agreement, but recently cabinet has approved and India has deposited the instrument in the WIPO assembly. So India will be soon the member of Strasbourg Agreement that establishes international patent classification, which divides technology into 8 sections or 8 classes, and with approximately 80,000 subdivisions. So this classification, the technology classification for innovations, uh, established under the Strasbourg International Agreement for Patent, is indispensable for the retrieval of patent documents in the search for prior art, for the novelty test, and such retrieval is needed by patent issuing authorities like our patent registries, and also for the potential inventors. Maybe among you, few inventors must be there, and also the R&D units and other concerned, um, you know, technology development and innovation companies. So India is seriously considering that make Indian patent laws in harmony with the international. So what changes? My topic also talk not only about the global compliance, what reforms India has introduced in the patent law recently. What are the recent developments? They recently, 2023, government of India introduced the patent rules, which finally notified in 24. The basic reform introduced in this is reduce complaints burden for the applicants. There's a lot of working statement submissions unnecessary every year they will reduce. Even the patent working statement reduced from 5 years, every year to
No, there are
the
people
number
who
of
are in the waiting room.
statements to be given
See, there
only
are people in the
uh,
waiting in this.
every 3 years, but not every year. That is the change we have made. And expedited examination in a recent reforms you must have
No, his
seen.
speech is going to complete.
Expedited
No, his speech is
examination
going to
of
complete.
patent
Okay,
registration.
unmute us for another one.
This has been, of course, Mr. Rana was talking about the expedited examination of patents for the startups, and also for the MSMEs, and also women innovators, the women startup companies led by women also have the reduced fees and also the expedited examination facilities. And another important development, a recent one happening. So, of course, India is considering seriously about the um, uh, improving the uh, registration conditions in the trademark law. I already mentioned you artificial intelligence, machine learning, such has been introduced and made available publicly, and also amending the trademark rules so that various innovations may be introduced for reduction of time taken for the registration of trademark. And India is already member of Madrid application of international application for registration of trademark can be filed under that uh, uh, system. And another important area development happened is the finalization of Riyadh Design Law Treaty. So, Riyadh Design Law Treaty was adopted in November 2024, last month, and sorry, last year. And India is seriously considering. And one of the legislations in IP legislation, we have a very weaker legislation as the design law. So India needs to improve is a design registration system by joining the Riyadh World um, Design Law Treaty. Procedural law, it's one of the procedural laws. India should join this, and another treaty which India needs to join is the Hague Agreement, because unlike we have the international filing system for the patent under the India being a member of a patent cooperation treaty, and India being a member of a Madrid agreement, we can file international application there. No such facility for the designs. So India should consider joining the Hague Agreement for international registration of industrial designs, and this will facilitate uh, 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 the more stronger protection for Indian designs, especially when Make in India is happening. And not only it is a kind of win-win situation for both foreign IP companies and also Indian companies, when many manufacturers from abroad and coming and manufacturing in India, they should be given this facility of international registration as well. And another disruptive thing development happened recently, again last year, that is establishing a new treaty called WIPO Treaty on Intellectual Property, Genetic Resource and Associated Traditional Knowledge. This was finalized in May 2024, last year. So this treaty establishes a mandatory patent disclosure requirement, and this requires that a patent applicant has to disclose the country of origin of genetic resources, or, uh, or from which indigenous people community or local community he has taken this genetic resources, providing the associated traditional knowledge if the claimed invention are based on these genetic resources are associated traditional knowledge. So India is also seriously considering this, um, and it is important for India to join, because India has been traditionally been protecting the traditional knowledge. You all know that traditional knowledge, digital library (TKDL) has been created by India after various misappropriation and biopiracy issues came up, like someone patenting haldi related products, or neem related products in US and EU. And this traditional knowledge digital library helps those IP officers in a prior art search to find out and invalidate if already granted patent, or no patent should be granted for the traditional knowledge associated genetic resources matters. So India is one of the signatories of the Convention on Biodiversity, the, which happened in 1992, and subsequently, there was a Nagoya Protocol to on access and benefit sharing. They basically the Convention on Biological Diversity and Nagoya Protocol, uh, says that there should be equitable sharing of benefits arising out of the use of traditional knowledge, biological resources and traditional knowledge for patenting. This recognized by India introduced Biological Diversity Act in 2002, and under that National Biodiversity Authority has been set up. Our patent disclosure mechanism clearly mentioned that it has to be disclosed. There is a consent has to be taken from the National Biodiversity Authority, and there should be access permission should be there, and also there should be a benefit sharing as per the principle approved by the National Biodiversity Authority. So these are the mm, policy mechanisms which India has introduced, and to move forward, India should join the WIPO GR Genetic Resources Associate Traditional Treaty, which was established in 2024. That government is actually considering. And another area, the most controversial area, is the lack of standalone legislation or a sui generis legislation for trade secret law protection in India. So then, how trade secrets are protected in India? Uh, Trade secrets are protected in India by various methods, by way of Section 27 of the Contract Act, through the common law principles, by misappropriation things, and the a couple of provisions of Copyright Act and IT Act, and all these are applied here. But the Law Commission has given its report 289 report in 2024. Recommended, it given a kind of draft legislation also, recommended government to introduce a sui generis legislation. This is being examined in India, a couple of departments, and soon they may take a decision of introducing sui generis legislation. And another important reform in India, it has happened about the protection of plant varieties. Protection of plant varieties is one of the important decisions which was taken when TRIPS agreement was being negotiated, because there was already existing international treaty called Union International for Law Protection this Obtention Vegetable. It is called the UPO Treaty, International Union for the Protection of New Varieties of Plants in English. It is UPO of farmers' rights, following the flexibility given in the TRIPS. TRIPS says that the member countries may protect plant variety either through the patent system, or it may introduce a sui generis law to protect the plant varieties. What the existing UPO system does, it recognizes the big companies like Monsanto or other companies, their innovation, their researchers only, but not a farmer who by tilling the soil, he may come out with the new varieties of plants. So India recognizes even a farmer is a um, plant variety innovator, and also his right to seeds also been farmer is a breeder, and also he has rights over the seeds. Uh, so these are the new innovative things India has done. And another important development, which the most exponential developments happened recently, that is introduction of two treaties, WIPO Copyright Treaty and WIPO Phonogrammes and Performances Treaty. These two treaties, extended protection the literary artistic works from the Berne Convention times to physical environment to digital environment, because protection of all copyright works important even in the digital environment. Now, all digitally accessible copies are available. whether it is a literary work or artistic work or music or film. So the world needed a new way of protection to extend the uh, copyright protection to the digital environment. That WIPO was done in 1996, the first internet treaty, that is the WIPO copyright treaty. And similarly, sound recordings were given reforms in India. Indian government has introduced certificate of patentability issued even for the inventor. Inventor certification was introduced apart from the grant of patent certificate. Sometimes patent grant may go to the institution, but the person, the inventor involved, may not be getting a certificate. So, certificate of patent, the inventorship certificate we introduced, similar to other countries. And again, the copyrightability. Again, the natural person has to be the author, but not the legalistic or the juristic person or a non-human cannot recognize author. And the another latest controversy happening about whether text data meaning exception to be given uh, to the AI companies or not. Of course, the EU in its common digital market directives, single market directives introduced in 2019. In Article 3, it grants text data mining exception for the research, non-commercial research. But in the Article 4, it grants for the commercial research with the opt-out mechanism. This model was taken by the UK recently in a digital data act bill introduced in the parliament, UK parliament, that has attracted a lot of controversy. And basically the inventors, especially the creators and copyright owners, are saying that the AI companies cannot come out and churn out and give an output because their input is based on the pre-existing data. The AI training is happening on the pre-existing data, and they are like a parasites preying on our works. And now, innovation can't go on like this. And if you see the example given by the UK artists, about 1,000 UK artists came out with an empty album called "Is This What You Want?" The title. If an AI machine crawls into that empty album, you can't scrap anything, scratch anything, because nothing is there in that empty album. It is a best example that all AI machines can't work without a pre-existing data. The very basis of AI training and the AI learning and final output is given to you when you go and ask a question to it or give a prompt to it. So it all happens uh, uh, based on the already uh, works which have been created and made available, whether it is literary works or artistic works like photographs or the music or video. And EU has come out with the EU AI Act. Of course, they have recognized the importance of the transparency and accountability and all that, and how AI models have to function. That I mean, detailed information and instructions in the recent annexure to the Section 53, sorry, Article 53 of the EUA Act. And of course, US is silent on that. US Copyright Office, of course, has come out with the three reports how a copyright should be recognized, and there are two judgment recently in the US courts, one on a meta case by Judge uh, Chabria, and another Anthropic case. Judge Alsup has given a controversial judgment, which may be appealed in the US Supreme Court. But this is the new developments happening elsewhere in the world. And in India also, the Associated News of India, ANI, has filed a case against the OpenAI and other companies about using their databases without consent and compensation. And following this, Indian government has also appointed one, constituted a committee to examine and come out with a policy paper on the issues related to artificial intelligence and copyright law. So a lot of important things are happening on the policy side in India, and a lot of modernization of IP offices is happening with the patent, trademark,
They like board games.
copyright registration to expedite the registration and reduce dependency. And India is committed to the motto that creative India and innovative India, as mentioned in its national IPR policy. With this, I again thank Professor Benjamin, Professor Srinivasu, and the colleagues for giving me this opportunity. And thank you very much, Jai Hind.
Thank you,
Thank
sir.
you,
Thank
sir.
you
Thank
so
you
much
so
for
much
your
for your
comprehensive
comprehensive
insights
insights
on
on
the
the
topic.
topic.
We
We
now
now
move to
move to
the
the
keynote
keynote
address.
address.
I
I
invite
invite
the
the
host team
host team
to
to
introduce
introduce
Professor
Professor
Srinivasulu, the
Srinivasulu, the
keynote
keynote
speaker
speaker
for
for
today.
today.
It is a matter of great honor and privilege to welcome a truly distinguished academician and legal scholar to today's session, Professor Dr. Srinivasalu NS, currently serving as Professor of Law at the National University of Juridical Sciences, Kolkata. Professor Srinivasalu is a widely respected figure in both national and international academic circles. He is a distinguished member of the International Council of Jurists, London, and a scientific member of the Canadian Institute for International Law, Ontario, Canada. He is also affiliated with the World Commission for Human Rights, London, reflecting his global commitment to advancing human rights. Professor Srinivasalu has played a pivotal role in shaping public policy. He has worked with various ministries under the Government of India, including the Ministry of Justice, Ministry of Commerce, Ministry of Human Resource Development, and Ministry of Transport, as well as with the University Grants Commission. He has also offered
If he's
policy
not there,
advice to
don't
several
mind.
state governments,
If he's
including
there, fine. If he's
Karnataka,
not there,
West
happy
Bengal,
to finish the
Assam,
program,
and
sir.
Goa, especially on matters of legal education
If he's
and
there,
law
fine. If it is
reforms.
not there, then
Professor
I'm happy.
Srinivasalu's blend of deep academic scholarship and practical policy engagement makes him a rare and a valuable resource in the field of legal education. His insights are bound to enrich our understanding. Please join me in extending a very warm welcome to Professor Dr. Srinivasalu NS.
Good evening,
Good evening.
respected Professor Benjamin, Professor Kondaya, Professor S.C. Roy, Dr. Raghavendra, and Dr. Vikrant Rana, and also two of my young colleagues, Hashim and Sarah. Since we are running behind this time, I will try to keep myself a little short. Though it is a keynote speech, it's like a key will be very small, but when it opens, when it operates, it provides access to big rooms, buildings like that. So, however small, however short it could be,
This camera is off.
doesn't matter. But how effective it is, that is going to be the thing that
Yeah.
gets considered.
Milan.
Having said that, I'll start my talk with the two caveats. One caveat is that when it comes to employability,
Sir, he will be
in
speaking a
particular,
short time.
employability in India is
Professor
concerned,
Sira is there and
60% of the Indian
off the
populace
camera.
depend on agriculture for their employment, where our intellectual property rights, R&D, may or may not have any influence. If it has, it will be having very limited influence. That is number one.
I told
Second caveat that I would like to put across is, the moment you get a patent, the moment you get a trademark,
now Karan gone.
it doesn't create employability.
That's university made intentionally.
That patent has to be commercially exploited.
In heart. He teach everything in heart.
It ought to attract investments.
Cities of the devil.
It has to be executed. For that, not only science and technology initiatives are required, but business entrepreneurs who are ready to invest in exploiting that invention or in exploiting that copyrighted work is required. That can happen when you are a patent owner, a copyright owner, a designs owner is ready for
Milan.
training and technology transfer.
Does not spend from his pocket.
If whatever invention which you have invented, whatever literally artistic and the like copyrighted work that you have created, if it is with you and you don't want
I
to
did not know him. When I
push it into the open
after I
market,
knew him, I was regretting why
it cannot create employability.
I realized.
Employability gets created basically because of the investment. And for people who are investors, for them, the number of patents, the number of copyrights, the number of trademarks, designs, whatever you have, would provide value addition. Number one. Number two, every patent, every copyright may not essentially result in purely commercially exploitable venture. For instance, as of 2025, we have granted 1 lakh patents in our country. Out of this 1 lakh patents, hardly 50,000 patents may get into industry. Hardly 50,000 patents may attract investment, based upon which you can talk about employability. Similarly, number of designs that you go for registration, trademarks or copyrights, half of them may or may not attract any investment for its commercial exploitation and stuff like that. So the employability, the factor of employability, whatever we are trying to debate, it is not purely and essentially dependent on number of patents that you get, number of copyrights that you get, or number of designs that you get. It's about getting those patents, those copyrights which are industrially exploitable. I'll give an example. During times of COVID and all, India came out with a couple of vaccines, Covishield, Covaxin and all. Serum Institute of Pune, Bharat Biotech, Hyderabad. They were bestowed with, they were asked to work on that. The moment government of India gave that task to them, they recruited hundreds of scientists, basically pharmaceutical scientists and biochemistry people, to work on work on finding the vaccine. Similarly, it happened in Russia for Sputnik, in USA for Johnson and Johnson. This is one example. When because society needed it, there were people ready to invest. In case of Covishield, Covaxin, government of India only invested, and that it generated. If a biochemist or if a pharmacist or a person who is into pharmacy, if he or she is having a particular idea with reference to an invention, or he or she has done that invention, and it is there in his or her books, in whatever scientific steps that he or she followed and all that. But when it is not attracting the industry, when it is not attracting the investment, creation of employability may not happen. Perhaps all the 7 different areas of IP, whatever we have, all are connected with one or the other industry. If at all those IPRs are going to be commercially exploited, those IPRs are going to attract investment. there are certain identified industries where from that investment can flow in or where from that commercialization can take place. For instance, in case of patents, health industry, food industry, beverages industry, and manufacturing industry. So whatever patent that you come out with, your target will have to be these 4 industries in general, substantially. So a patent, the inventor will have to read the market, at least in these 4 sectors or segments of industries, and try to come out with such kind of invention which will add value to the existing knowledge in those 4 spheres of industry, as I said, health, food, beverages, or manufacturing. And you need to attract those people who are there as investors in these 4 sectors of industry who can come in and invest money so that you can generate employment and all that. Similarly, in case of copyright, we have media industry. When I say media, ranging from print media, radio, television, films, and digital media. All that you copyright will go to any of these 5 medias only. It doesn't go anywhere else. Right? Any copyrighted work for that matter, literary, artistic, architectural, dramatic, musical, sound recordings, and audiovisuals, will go into these 5 industries only. Right? Different expressions on different platforms, different copyright. And perhaps my IP fellow colleagues must be having an idea about it. The age-old Convention on Intellectual Property, Paris Convention, did not cover copyright, because copyright was considered to be non-commercial. It was considered to be for divine purpose. Only of late, because of the growth of media, where different types of copyrighted works are being exploited in different ways, that is when industry realized that copyrighted subject matter could also be industrially viable. Now just imagine in the past 2 or 3 decades, how many television channels we have? In each and every language, minimum 100 channels are there. Right? India is the land of languages. Right? More than 20 languages are being recognized as official languages, excluding Hindi and English. So as many as 25 different languages, you have television channels. So each 100 channels means 2,500. How many people are employed over there? And all that gets exploited there, executed there, presented there, telecasted there, broadcasted there, is coming from your copyright field. Of course, nowadays print media is going down because people are getting digital media on their mobiles only. They get news and all that. So one media may be having tough time, but other medias, including your radio and all, they are growing because of the exploitation and commercial viability of copyright. 20 years back, 25 years back, or earlier to your globalization and all, it was not the scenario. Media was confined to more or less radio and newspapers. Now the phenomenal growth of media is generating a lot of employment, and entire media is dependent on copyright, or are the works that you protect under copyright. What I'm trying to say is, because media needs copyrighted work, or media needs copyrightable work. It's not that everything that you broadcast, everything that you telecast, everything that you print is actually copyrighted. But it could be literary work, it could be audiovisual work, it could be artistic work, it could be musical work, sound recordings, whatever you will telecast, broadcast, print, all that. Right? So whatever happens in all the 5 medias is nothing but these 7 subject matter of copyright only, whether you protect it or not. Of course, you need not protect copyright because it is a natural right. The moment you create something, it becomes yours. The point is, because of the growth of media industry, there is a demand for copyrightable subject matter. And earlier also there were copyrights. For example, Shakespeare works or R.K. Narayan's works, Picasso, painting and all, these things were never copyrighted. But even today, everybody knows who they are and nobody will try to copy it. Registration of copyright is a recent phenomena, and especially aftermath of globalization, because of the growth of media, because same copyright can be exploited in all the 5 medias. There could be 5 different copyrights because 5 different expressions, 5 different platforms and all.
Webinars.
So media industry, which is connected with copyright, it is generating employment by using, exploiting copyrightable works.
I mean, if the
When it comes to
university asks you how
trademark,
many programs
trade
have
and
you
commerce industry
attended or you
in
done,
general, because it is them who will try to spell
and if
out
you
their
require, I will
business
screen record them
identity
tomorrow.
through using a sign or symbol.
You don't need it.
People use
I'm
trademark, business
saying if
people
you need,
use
I can give you.
trademark to mark their identity in the market,
Yeah.
in any given market. Business people use a trademark to attract consumer. So when trade and commerce people started getting little creative, started deploying different tricks and strategies to expand their business, to capture market, to attract consumer. That is where they started thinking that no trademark using a sign symbol or an attractive music tone or an attractive audio visual, an attractive graphical work or attractive logo, attractive painting by which I can attract the consumers in a better way, right? So it's all it's nothing but a bridge between market and trader, no? So it's again part of business tactics only. But whether usage of trademark is really
If we see
generating employment, if you ask me, I say yes, because when business grows, when you capture market, when you attract more and more consumer, you need to produce more and more.
No,
It could be goods or it could be services. That more and more will have to
more and more.
be supported by more and more employment. So growth of market, if your trademark can envisage, grow, betterment of consumer base, if your trademark can envisage, that would result in employment generation. Basically to keep up with the increasing demand through the growth of business and whatsoever. Similarly, when it comes to industrial design, basically two industries are connected with this IPR designs. One is manufacturing, the other is automobile. Substantial amount of design works would go into these two sectors. That's why when, as IP scholars, when we go and deliver lectures in science and technology departments or business departments, commerce departments, we always say that try to work on something which is required by the market. Simply for the sake of you doing it, don't go about doing R&D. Before embarking on R&D, look into the market, what markets demand, so that your invention, your copyright, your design, your whatever can have the commercialization, better ways of commercialization, or better means of commercialization. So in the manufacturing industry or in the automobile industry, especially when it comes to outer layer, outer skin and all that, more and more innovations, more and more design registrations, if they can attract the market, attract the consumers, it can also lead to more and more demand and more production needs to be supplied, ventured into. And that is how, once again, this IP segment can also create employment. So what I'm trying to say is, it's not just about a scientist coming out with an invention, a tradesman coming out with a sign symbol, an artist coming out with a copyrightable work, or an industrial entrepreneur coming out with manufacturing or automobile industry connected design. It's about coming out with something which is having market demand. If it is having market demand, if there is investment, if there is commercialization viability, then only employment gets generated. So that's why we need not go with the 1 lakh patents that Government of India granted this year in 2025, 6 lakh trademarks that Government of India granted in 2025, right? Half of them may not get into industry at all. But when it comes to the calculation and presentation, especially at government level, they will present that this many patents and one patent into this many employment, like that, this many employments it generated, 6 lakh trademarks into this many employment, like that, they will, in general. But half of it may not actually enter into industry at all, so that employment generation can take. Similarly, when it comes to geographical indications, which is basically meant for commercializing handicrafts, and traditional knowledge based products. The fact that as of 2025, Government of India granted 600 plus GI registrations since 2003. In most of those traditional products, manufacturing products, or agricultural products coming from a particular locality, growth has taken place. I can give my own example of Mysore, where Mysore silk, Mysore pak, Mysore agarbatti, all that is being produced. Aftermath of giving GI registration to Mysore pak and Mysore silk in particular, not only in Mysore, even in Rajasthan, Mysore pak is produced. Lal's Mysore pak. Even in Uttar Pradesh, Mysore pak is produced. Agarwal's Mysore pak. But whereas our GLA says it is coming from one particular locality and all that. Now, similarly, your Banaras sari is also produced in Hyderabad. Kanchivaram sari is produced in Banaras also. Especially, it is very difficult to control, stop, and regulate manufacturing products. In case of natural agricultural, nobody can venture into because it's all depends upon the climate and fauna and flora of that land, climate, everything. But in case of manufacturing, right, where nature doesn't play any role, so that manufacturing unit can be established wherever it is. The fact that the Mysore Pak or Mysore Silk became a brand, number of people started producing Mysore Pak in different parts of the country. And it led to creating employment. Same is with most of, especially manufacturing products, handicrafts, whatever we granted GI protection, all of those things have gone beyond that geographic locality. And we have now umpteen number of such handicrafts, traditional knowledge-based manufacturing products being set up, which are generating employment. But of course, compared to countries like Austria, very small country with less than 2 crores population, they have got 3,000 GI registrations. USA has got 17,000 GI registrations. China has got a 20,000 GI registration. And India being the, in terms of population, number one country. 600 is very, very less. Of course, that one product, one district, one product, by virtue of which, all the 560 odd districts that we have in this country, beyond the GI I'm talking about, there also some branding has taken place in order to push the marketability, commercialization of those products which are special in that particular district. So now 565 odd or whatever districts that we have and 600 GIs put together more or less roughly 1,200 locality specific products we are promoting through IP or whatever. And once it becomes a brand, people start producing it, elsewhere as well. And because we have that psychology mindset that we go for brand factory only, right? Because we believe that the brand will give quality and we will have satisfaction. Whether it is real or not, that's a different story. But our mindset is like that. So when our mindset is like that, so once it becomes a brand, right, that branding will lead to merchandising, and that merchandising will lead to employment generation in the GA sector. And of course, the plant variety sector, as a couple of the other two speakers were also mentioning about it, the weakest IP segment and all that, of course, which serves the agrarian economy, where 60% of our employment is actually based. 60%, as I mentioned in the beginning, 60% of Indian population defined agriculture for their employment. And for plant variety, agriculture is the industry. Of course, agriculture is not recognized as industry because of commercial reasons. The moment you are declared as industry, you need to pay a tax. But now agriculture is, then only the employment generation can take place, right? So IPR are the stakeholders of IP and the stakeholders of industry. If they go hand in hand, proper exploitation, proper execution of IPR can take place, leading to employment generation. This is what I got to say. Thank you.
Another student said that, sir, I have hobby of photography. How can I earn money out of that? See that. One said that I have a hobby of writing poems, writing stories. How can I earn out of that? So awareness, not only that what are intellectual properties, rather copyright, patents, trademark, design, so many things are there. Then, but how can they register and how can they commercialize? And in this way, they can earn money. And here again, self-employment. Employment does not mean that government job. Employment does not mean that only one can have a office job. Rather, employment means business propagation, creativity, and commercialization. So, how can they do? Here is a problem that we require. And if we do that, really there will be employment generation, our economy will grow, and we will be in a position to achieve third, superpower economy in the world. Second is that the generation of IPR, generation generate IPR. You see that public funded intellectual property rights bill of 2008 could not be passed in the parliament. It was brought during the regime of Kapil Sibal sir, but could not passed. What was the reason? The policy was that the university should be connected with the industries. Curriculum should be developed accordingly. And accordingly, there should be teaching also. Presently, the intellectual property law, it is being taught in the universities or law colleges. And I am sure many of the audience may accept my statement or may not, that there is a lack of teaching fraternity. There is lack of research in intellectual property area. Here is a problem that we require a pool of people, hub of people in this area who are well versed in intellectual property law and can disseminate the knowledge. There is a lack of that. And if it is so, then how can we generate? Another issue is that we have a lot of engineering colleges, medical colleges, polytechnic colleges, in IITs, ITIs, Industrial Training Institutes. So many institutes are there. What is happening? Whether they are learning as per the prescribed curriculum or they are learning skill and applications also. This is a question. And our new education policy that the government has emphasized and pressurizing that there should be skill development, and it is not happening. Skill is not being developed. So how can we generate? And if there is a skill development, trainer will be there, teachers will be there. They will motivate how to develop, how to groom the students, children. Automatically, there will be creation of so many instructors, teachers, skill entrepreneurs, and obviously there will be skill development and creation of the job. So generation of intellectual property, it requires a person who is a teacher, motivator, instructor. Of course, this will generate in this area the jobs. Third policy, that legal and legislative framework. See that we have laws, but we see that still we haven't trade secret laws. Still, and we have a pressure from developed countries that you must have a strong uh, protection of the trade secret laws. A strong IPR regime should be there. Many people advocate. Of course, a strong IPR regime is essential. And if there is a strong IPR regime, it doesn't mean that there will be no infringement. There will be no breakage. It means there will be a requirement of intelligent advocates. See that in the age of artificial intelligence, now we have entered into. Now we have to compete with human intelligence, with artificial intelligence. That we are doing something and the law is protecting, but the artificial intelligence is interfering into our rights and taking away and infringing. How can we protect ourselves? And here is a requirement of intelligent advocates, engineers. So technology with law, it is a first and foremost uh, requirement. And again, I would like to say, as per the National Quantum Mission, our government of India has started quantum, uh, calculus or quantum mechanics. Now it is subject of physics, but now it has entered into the subject of creativity. That in the industry, unless and until we enter into the quantum algorithm, quantum computing, there will be no progress. It will be difficult for us to be industrially developed one. So we have entered into that phase. And yes, of course, the patents, copyright, trademark, design, everything will have to be changed. So we require science oriented advocates, BSc LLB advocates. We require, and of course, this will create job. This will create job. So legal framework, it was essential, it is essential, and in coming future, it will be a very, very significant one in the era of artificial intelligence and quantum calculations, quantum mechanics. Administrative and management, we have everything. As I can draw the attention that earlier we had a FERA Act, Foreign Exchange Regulation Act, but now we have a FEMA, Foreign Exchange Management Act. What is the why there is a shift? The reason behind is that the shift is that earlier we had shortage of foreign exchange, but now we have a pouring of foreign exchange. Therefore, therefore we have to manage. We have abundance of funds. As you see that the government has started freebies from where? It is because the taxpayers' collections and the earning. Therefore, we are not in a deficit. We have surplus. Therefore, we have to manage. So, yes, of course, there is a intellectual property creation every day, everywhere. But at the same time, how to manage, how to transfer the technology, how to use it, as climate change is the biggest issue. But whether we are in a position to develop technology or whether we are depending upon the north only, so we have to generate, create, and protect also. Commercialization, the same thing, that if we have a knowledge, awareness, but we must have a skill and support how to commercialize. In this area, I would like to draw the attention towards the SMEs, that small, medium enterprises, MSME, and startup. Two things which has taken, it is a matter of discussion today everywhere. Startup people are talking about, MSME people are talking about. But how MSME can thrive, how MSME can grow, how there can be more and more production. Because if we want creation of job, employment, first of all, we will have to enhance production. Make in India and Made in India is the project or slogan the same. It is because of that we have to maximize production. At the same time, qualitative production. For this, there is a requirement of patent. And patent, because there is inventive steps, technological development should be there. And unless and until human mind is invested for the development of the technology, inventive steps, there shall not be either in process or in product. Okay, we can't expand, we can't improve, we can't have a more and more production. And if there is no production, there will be no commercialization, no marketing, no jobs, no economic development. So therefore, in this MSME sector, it is also essential. So I think that, and enforcement education is the same thing. One most important seventh point in the policy is that human capital development. Human capital development, that through awareness in the first choice, first point, there is a requirement of when there will be more and more awareness, more and more motivation towards creativity, then naturally human capital well versed in intellectual property assets will grow. So intellectual property can help in development of the employment. Now I'd like to say that what to do. What to do? Still we see that we are talking about China has developed, Korea has developed, Japan is developed, USA is developed. But one problem we have in the patents law. See that we have a patent and 20 years time period is there. And you see that in getting the patent granted, it takes 3-4 years. So what happens that the person for 12 to 14 years or 15 years, they enjoy the patent. And the investment is so much, so high that the cost is very high. Now, this is why there is a duplication in pharmaceutical industries also. This is a problem. So here and China, you see that sometimes people have a sarcasm against the Chinese goods also, that the Chinese goods are short-lived, transitory. As we know very well of the toy industry, that the China was dumping and we had an anti-dumping act to protect our toy industry. What was the reason? What is the reason? Reason is that India has not recognized still even petty patent. Why not India should introduce petty patent? This is a, if we want more and more industry, if we want that the goods should be cheaper, if you want there should be speed up in a MSME sector, startup sector, small scale sector, kutir udyoga, all these things should grow. We should introduce a petty patent system also, so that there should be minimum investment, maximum production, and maximum trade and development. So the petty patent is one area that should be taken into. Another thing is that there should be, why not there should be intellectual property audit. Presently there is no audit. I have invested industry, I have in the industry. We demand foreign investment, we demand technology, or we demand machines, but where is audit? There is no IP audit. We have a financial audit, no intellectual property audit, that how much investment is there and how much there is a output. We are lagging behind in intellectual property valuation. If I have invested, copyright in a patents, in trademark, in design, so where is the valuation of those IP products? So this is a problem also. And if we can take care of that, investment in the valuation, investment in the audit of the intellectual property, naturally we can grow. Our business can thrive. So initiative is required in order to develop our intellectual property areas. Legal assistance is also required. And in this assistance, there can be that how much support is required. That is also very, very important. Insurance sector, you see that, okay, we have an insurance policy of a human being, insurance policy of a building, insurance policy of machine, so many things are there. That whether we have insurance policy against the intellectual property assets, unless and until we have a valuation of the intellectual property, suppose valuation of the patents, valuation of the trademark, valuation of the copyright, how can we have an insurance policy? So therefore there is a requirement of insurance, IP insurance policy also, because we are not taking care of the value of the intellectual property insurance, whether on the basis of, suppose you are author of a book, and whether it can be mortgaged or not, whether it can be mortgaged in the bank, and out of that the person can have a revenue out of that, and you can invest your money somewhere in business. This is the issue. So if someone is a graduate one, he has written a book, okay, of course that is the property, and it can be mortgaged. When it can be transferred, it can be assigned, it can be sold, it should be mortgaged also. Let the people earn out of that and do business. So as well as security also, insurance, IP valuation, IP audit, insurance, all these issues are essential if we want really that intellectual property rights must contribute toward the generation of the employment. Uh, Likewise, another issue is related to license actions, technology transfer. Whether why not we are creating an environment here so that our best mind from IITs, IIM, and medical institutions should drain towards the UK and USA and to European countries. This is the reason that our brain, excellent brains, bright brains, they are moving towards the developed countries, and they are unable to have a facilities of research and development. So there the requirement of research and development institutions uh, in universities. One I have come across to the some of the IITians, and they say that there is a lack of research and development department in the institutions, and this is why people migrate here and there. So if people are migrating, unless and until we invest in our research and development organizations, how can we create job? This is a one biggest problem that has to be taken into consideration. So another is one point very important: patent pool. Patent pool. We have heard about the term carpool. Carpooling means if you have one car, your neighbors, 3 4 people can use that car and go to the destination in order to minimize environmental pollution. Carpool. Likewise, patent pool. Patent pool. This is most important issue which is capable of creating employment. Patent pool, that is a contractual arrangement among two or more patent holders to grant license for one or more of their patents to each other, to the third parties. If 2 3 people have a patents, they can provide patent to somebody else. They can motivate other people also, and in this way the employment can be generated, wealth can be generated, business can be generated, and of course employment can be generated. So the patent pool system is not available. Another thing is also very very important, that yes, we are getting registration of the patent. Okay. And the government is also claiming that we have a huge number of patents registered in our name, but what is whether the patent is working of the patent is very very significant. If it is not working, it will not create business, it will not create employment, nothing. As we see that many of us are saying that uh, patent is really not working properly, and people say that 80% of patent is not working. Why not the compulsory licensing policy is being implemented? In NATCO case, only one in case that compulsory licenses has been applied. Why not in all cases which is not working for the last for 3 years? Yes, it should be license can be granted to somebody else, and naturally if it is working, business will be done, and naturally there will be employment. So working of the patent must be taken care into. People are saying that yes, we have so many things. Likewise, registration of the geographical indications, it is on the door. Employment is on the door, whether the people have knowledge of that. I have got empirical survey. Many people are not knowing what we are saying about the geographical indications related. They don't know what is geographical indications. They don't know if the price of the commodity will increase. Suppose if I am registered, I have a GI tag, and the price will increase, then what will happen? Who will purchase? Where is the market? Whether the government will protect, whether the government will purchase the mangoes. As we have consulted through the empirical research, I am taking you with empirical evidence that they are saying that yes, particular mango which is found in Bihar, yes, it is a GI tag. But of course, price is increased. Who will purchase? It is a problem. Yes, yes, you can sell in the market, but who will purchase? Whether the government will protect or government is going subsidize or doing anything? Answer is no. If there is a less sale in the market of the same goods, what will happen? There will be no increase in the business, and further there will be no employment. Therefore, the people who are the champions are saying that registration, GI registration, GI registrations. We want to say that whether it is increasing the sale, increasing the employment, there is a question mark. So, patent school and GI confidentiality safeguard also. It is also one thing that technology we are talking about, that trade secrets. You see that if someone is not eager to disclose the invention, okay, he will keep it as a trade secret. But in the era of quantum mechanics, quantum calculus, and algorithm, as there is a fast development, can we keep the trade secrets? What will happen? Therefore, we have to think over also in this regards. So, in this way, we see that unless and until we invest our mind towards creativity, and there is a support, and there is a just a market in the vicinity, that our creation will be commercialized, and protection through law, there cannot be creation of the job or employment. I think that with this positive note, not I am not negative, that intellectual property rights, or the we students of intellectual property rights are negative. Rather, we are positive towards copyright, trademark, design, everywhere. Awareness is required. At the same time, entrepreneurship motivation is required. Atmosphere in the schools, colleges, everywhere, in the training center, IITs, everywhere. Application based creativity of the mind is required. What is the mode of pedagogy, the teaching, it has to be enhanced. And only then there can be a movement towards the intellectual property assets creation and the job employment. Of course, a lot of umpteen possibilities there, that really if we follow the national intellectual property policy, of course we can uh, we can remove, we can say, I can say that employment unemployment issue can be totally and totally it can be mitigated. So, with these words, I'd like to thank you. Thanks to the organizer, Professor BS, and Professor Srinivasulu, and all the my Bikram sir, GR Raghavendra sir, and
Let's introduce Professor C. Roy.
Kondaya Saab, Professor.
Then
Uh,
we'll go for the next.
Virtually we are looking each
Let's
other.
introduce.
So, thank you.
Thank you, sir.
Thank you, sir. Thank you so much for your thought-provoking,
And we are
and we are really enriched with your distinguished speech. So
we are extremely,
we are extremely sorry for the technical issue. We could not introduce you in the first. Now I would like to request my teammate to introduce you. Then we will move to
the next
the
speaker.
next speaker.
Ms. Sarah
Ms.
first
Sarah first introduce
Professor C. Roy.
Professor C. Roy.
I have to introduce myself.
No, where?
No, where? No,
sir.
The host.
the host.
Introduce.
to
Oh,
introduce.
Due to technical
myself,
issues,
I am
she could
a
not introduce.
Sir, I will, excuse me, sir. I will be introducing you, sir. Because of the technical issue, I couldn't introduce. There was a network issue.
Yes.
no problem.
Yes.
Yeah, please proceed.
Yeah, please proceed.
Okay. It is an honor to introduce our distinguished speaker, Professor Dr. Subhash Chandra Roy, a leading academician and legal scholar, currently serving as the Dean of Research and Development and Director of the Center for Innovation Research and Facilitation in Intellectual Property for Humanity and Development at Chanakya National Law University, Patna. With over 2 decades of academic experience and a multidisciplinary foundation in law and English literature, Dr. Roy is a renowned expert in intellectual property rights, legal education, and social legal research. His scholarly contributions include authorship and editorial work on numerous books, such as Lectures on Intellectual Property Law, An Analytical Study of IPR in India, and Oscar Wilde, Legal Wits and Conversation. He has published extensively in reputed national and international journals and has presented research in over 100 seminars and conferences both in India and abroad. Dr. Roy has held several key academic leadership roles, including serving as the Internal Quality Assurance Cell Coordinator, Academic and Research Coordinator, and Mentor Mentee University Coordinator. He has also supervised and evaluated a significant number of LLM, PhD, and LLD dissertations, reflecting his deep commitment to mentoring the next generation of legal scholars. He has represented India on global academic platforms, including conferences in Singapore and Malaysia, and collaborated with institutions such as Northumbria University, UK, and various national law universities. His outreach extends across disciplines from law to environmental science, public administration, and pharmaceutical education, reflecting his passion for interdisciplinary and socially responsive legal research. We are privileged to have Professor Dr. Roy with us today. His insights into intellectual property, academic innovation, and legal pedagogy will be of immense value to our discussion. Thank you, sir.
Thank you.
Thank you. Thank you,
Thank
sir.
you. I have presented already that we have a lot of opportunities, we have a lot of scope. If really we implement the national IPR policy perfectly, honestly, not only perfectly, honestly, if we implement, and really we can achieve the goal of employment and maximum employment issues can be fulfilled. I would like to add just in the last, because our next Professor Kondaya sir is also uh, waiting. Sir, I am taking just 1 minute
No problem.
from you.
No, please.
That IPAB, Intellectual Property Appellate Tribunal, has been deleted now. But and the parliamentary committee is also recommending that it should be restored. And one issue that I would like to say and leave upon the audience to think over, that section 3K of the Patents Act 1970, that requires to be revisited also. It says that there shall not be any patenting of the abstract ideas, mathematical models, this that. But you see that what about the algorithm? Algorithm, it is that it is essential. Quantum calculus, it is essential for our next generation innovations. We have entered into, and we have national quantum mission also. All the developed countries, they have national quantum missions, and the government of India has invested thousands of crores in this area, although it is not enough, but it is presently enough. So therefore, we will have to look into section 3K of the Intellectual Property Patents Act 1970, so that we can have more and more research in the software area, and there can be more and more jobs. Because nowadays what we are finding that a lot of people, as we have 140 crores of population, lots of the students are coming, they are getting admission in that list. More and more foreign direct investment can be attracted and job can be created, and only then we will be in a position to achieve the goal of developed nation by 2047. Thank you.
Thank you, sir.
Thank you, sir. Thank you so much. Now we are also privileged to welcome Professor Kondaya, sir. I would like to request my host team to introduce her. Sir.
It gives me great pleasure to Jake Kondaya, a renowned academician and legal scholar with over 2 decades of teaching and research experience in the field of law. Professor Kondaya is currently a professor of law at Maharashtra National Law University, Aurangabad. He has served in various academic and administrative roles, including as the Vice Chancellor of Maharashtra National Law University, Aurangabad, and previously as the Chancellor of Maharashtra National Law University, Aurangabad. the Associate Professor of Law at National University, Odisha. At the National University, Odisha, he was also the Director of Distance Education, SWAYAM Coordinator, convener of postgraduate studies, and a member of the Academic Council. His early academic journey includes an extensive association with National Law Institute University Bhopal and the University of Madras, where he was a gold medalist and the recipient of numerous academic honors and fellowships. Professor Kondaya's research interests span private international law, corporate law, securities law, international law, and competition law. He has authored two notable books, Securities Law and Law Relating to NRI Marriages. He is also a member of the National Indian Competition Experts Cartel Working Group and under the Competition Commission of India. In addition to his academic excellence, he has served as a visiting faculty at several premier legal institutions across India, including the Gujarat National Law University, Gandhinagar, and the Ram Manohar Lohia National Law University, Lucknow, and the KIIT, Odisha. His contributions to curriculum development, postgraduate education, and legal scholarship are widely recognized. We are privileged to Dr. J. Kondaya to this international platform. We look forward to gaining from his deep insight and scholarly perspective. Please join me in extending a warm welcome to Professor Dr. J. Kondaya, sir.
Thank you, Sarah, for your kind welcome and with the great words. Hope I'm audible too.
Yes, sir, you're
Yes,
audible.
sir, you're audible.
That's right. Okay. So, before commencing my lecture, let me thank the Professor Dr. M.S. Benjamin, Dean Faculty of Law, Chairman and Professor of Law, Department of Studies in Law, University of Madras, University of Mysore, for inviting me to share some of my thoughts on this international webinar. And a special thanks to Professor Srinivasulu from NUJS, uh, considering my name and referring to this conference, which is online international webinar. And also my other colleagues, Professor S.V. Roy, and the members from the Government of India, Dr. G.R. Raghavendra, and Advocate Sri Venkat Rana, Advocate on Record, Supreme Court of India, and the Mr. Syed and others, and more importantly, all the participants who are patiently listening for last 3 hours. So I prepared a small presentation, which is something about the employment generation by the IP or whether innovation gives an employment. So my topic is not just confining only to the IP regime of India. We also move something beyond the territorial borders, emphasizing on innovation and employment generations. Then I'm sharing some of my thoughts, what it has come from the various reports and some sort of experiences. And I don't want to be repeated. Already some of the speakers earlier spoken with regard to the IP. This slide basically talks about IP is basically a right and which has recognized by all over the world. Now, the main focus of my today presentation is that mind and innovation. As some of the earlier speakers have spoken, when the creativity comes to mind, mind creates an idea, and idea you are having the value. Where value is going to be protected for some point of time, then you are giving different names for that. Either the patent, copyright, or whatever the 7 names which you are having. So when we consider the creation of the minds, it gives a distinctive things, and where these are comes as intangible property, which has a value, and 2 things for a value about the amount and also the durations. That is where you see there are the value of the 14 years or 15 years or 70 years, depending on the property which I have. So I can keep some sort of properties. And every mind has an idea. Every idea needs to be vetted and in a boots or in a boot camping. Once your idea has a value, economic value, then it comes into the market. Once it has a marketability, then you design which category of the IP it comes. Then you start protecting your right and also doing marketing, and you yourself get an employment and giving employments to the others. So IPR covers basically various types actually. When you look at here, either artistic symbols, names, images, designs, and etc. etc. And there is a lot of fight is happening across the globe. Who is the first propounder of this symbol? And people start running and getting, this is my IPR, right? Because some of the developed countries will say, no, no, we are the one first who have found, and there's always a conflict between the two different states. In search of that, we have created the rights with the different names, like the starting from the patent, trademark, copyright, trade secrets, GI, and the traditional knowledge, and so on. It's coming on the types of the property rights. But we look into the right, which is a very simple concept created by virtue of mind as well as the importance. The another point which I want to say, there is a lot of economic impact where IP becomes as one of the underlying asset for individuals, for inventors, as well as for the state. Because state is one of the contributor for the purpose and promotion of the IP, where it also grades the development. Like for example, the state may allow the FDIs, and also state may allow the subsidies. I think now my slide is visible. They allow the subsidies and also certain schemes, because we have an idea, state try to provide, like individual can vet their ideas. That's why government of India has created lot of shares. Government of India is doing large number of outreach programs in the world, and particular to the India, how to develop intellectual property rights to reach to the real people who are not having awareness. Then moving further, we have international treaties starting from 1940s onwards, GATT, then WTO, TRIPS, and etc. Various names are there. So I'm not touching upon the theories, but there is an international body which talks and recognizes various ideas. Here I just have taken one example of culture and employment and business. I have taken one example of culture from state of Andhra Pradesh, where their product is bubbly veena. So it is being prepared as a special product, which are traditionally recognized in a particular culture. In a similar way, you have various properties across the globe, which has the geographical origins, and they are being protected. Let it be, you can call GIs, then you have agricultural products, and the specific natures which are given by the marketabilities. So therefore, my point here is that culture also has some sort of creation of business. Culture also provides the employability. So once you protect the culture, and automatically the cultural products or the cultural activities which the people will do, either handicrafts or maybe other type of product, will have its own markets. Then other one is IP, as I have already told, the important concept of IP, which comes majorly as the business. Now, I am coming to the another citations or another source from where I am going to start my lecture. According to the WIPO report of 2023 and 2024, they have studied about the 20 years of innovation capabilities, and they found a data which runs about 70 million scientific papers and $300 million of the economy. And they try to also look in the states who are increasing their economy by using of innovation. Then the WIPO report says that India has reached to the one particular state to the 42% to the 68% for last few years. Because India is one of the forefronter and also the providing the people to develop innovation. And innovation, we have the different names where we can say startups or the ideas, or some people they can come as the VCFs and alternative investment funds. So I have an idea. My idea has a commerciality. So let us protect my idea by business people or different name, and automatically Indian economy is increasing. And can you imagine that how many papers are available? What is the net worth of the
It's fine.
million trillions of economy where the people are looking into the international reports?
Fine, this is
So WIPO is very clear on that India is on a stage of innovations, digital market, and digital India promotion and increasing in the international sphere with regard to the creating of the jobs and also promoting of the businesses. And one of the employability comes according to the international reports, knowledge is consistently increasing, therefore it goes on changing to the fluid. When you talk about the mind will try to give you different thought. That is where the mind gives to you either the tools, missions, or the equipments. Today we have an equipment, I don't require to type. My speech can be automatically converted. Then people can say either AI or machine learns. So we have large number of devices developed over a point of time, computers, smartphones, autonomous vehicles. These are traded internationally, and we are one of the front runner of the development of knowledge and ICT sector. And there is also a lot of development of the specialization, as particularly with regard to the knowledge-based industries. Knowledge-based industries have a specialization and diversification. Some states may have development of a particular equipment, and whereas other states will have the development of different skill-oriented one. That is why one of the recommendation of WIPO is that let us make a specialized industries depending on our development, our financial status, state policies. So automatically in future, every state can develop by virtue of specialization in a particular sector. And also they will put another one is domain of the agricultural sector. Here we are talking about some of the examples of Nairobi and Kenya, where they are more using about the technology and agri-techs. So agricultural technology is also taken by using of technology as well as the more production. This is one of the examples which I have taken with the example of Germany. So there is a special skill labor which require for a special type of product or an agriculture. So the study says there is also mobility of a labor based upon a specific skill. So if the country or a place or a region is known for the a particular skill oriented one, even the farmers or a labor has that sort of business and increasing of their economy. So the example is from the Germany I have taken, where there was some sort of the plant, and that plant is basically called pioneer plants, requires then such sort of the expertises. Because of this expertises, German economy has grown much, and also there is a subject of knowledge transfer with regard to this impact of the development. The another important point which I want to discuss on my today's presentation is that for employment of the topic or employment creation of the IPR, or IPRs will create an employment, there are certain prerequisites. That is, there should have a macroeconomic stability. You should have the proper functioning of a legal system, effective educational system, and the financial system, and a better industrial policies. Unless these things are imbibed in any state, a state cannot progress on its own with regard to the what we can say the development of employment. Now, if you see today's example on today, Yesterday, or day before yesterday, United States of America has increased the tariffs on India. Now the whole parliament today morning, we had a discussion about the tariffs. So where there's a tariffs and subsidies automatically targets on development and promotion of the business, and development and promotion of business interrelated to the creation of the employabilities. So every state requires, that is why in India we have another example of ease of doing business for the promotion of employability, then also development of MSMEs as well as SMEs. So a lot of things have been developed in India in the sector related to the intangible assets. So where the government want to develop and make India as the best economy or a best place for the employment generation as well as employment supportability. Now, specialized economies we are not looking. Then I'm coming to another example is agri-tech. Agri-tech has become very successful nowadays because fertilizers, seeds, then crops, and develops about the food industry, or you can say industry of agriculture. When you see the Ministry of Agriculture in the state government of India or in a state, Agri has almost another 5 departments where you talk about the food and nutritions. And now the government is using technology with regard to the more production and also producing what we can say the nutritious food. Now, last year, the government of India has a project called millets bracket. The government says good for health is millets. Don't eat the rice. So if you want to have certain product which is good for health, good for nutrition, then we require about the production. So therefore, a society, if it comes as an agriculturally tech and technically savvy, and using of the tools, and automatically it comes to development of IPR, and this employment of IPR will give employment creation also. And this, we are all part and parcel of the development. Now, government of India is telling, and Delhi government is telling, if you have a vehicle more than 10 years or 20 years old, diesel, etc., under the principles of ESG or environmental pollution, don't come inside the Delhi. So therefore, the alternative comes for all of us is with regard to the electrical vehicles or no emission vehicles. So therefore, society is moving to the motorcycles, to the green vehicles. Either you can call this as a green revolution in IP, or you can say green channel for investments. Wherever you say we are having the electricals, and we have one more subject has come in law for investments. Just I want to put it for the students who are there. There is a subject called carbon credits and IP. Carbon credits basically says a creation of alternative energy, and this alternative energy is going to provide development of the state. So there is already a technology has come into the motor industry. So shifting to the batteries, lithium, and other electrical motors. So this makes us to the more products as well as with regard to the good and sustainable development, and as far as the future is concerned. This is one of the sector which I find very important for the upcoming years of the protection of rights with regard to the technology. Then another sector which is close to majority of us, video game industry and hub. Some of may be thinking how this video game is becoming as a business. And if you see the slide which I have taken from some WIPO source, video game is becoming a thriving creating sector and creating almost 184 billions of US dollars in 2023. It has done a lot with regard to the computing and entertainment and different sectors. And this economic activity has become economic activity located leisure and relaxation activities for many people, and the business has increased like anything in the world. So people, any shopping mall you enter, any place you enter, there are 2 to 3 floors are meant for the games. So revenue comes, people are creating entertainment. I was looking what are those games which are very famous, which are available. And the data says, with regard to these games which are mostly using Angry Birds and Candy Crush. I think majority of our laptops, mobiles we are having. And this has a more sectors. Though we pay for time pass, but there is somebody who created this app and there is somebody who is creating the business. As you can see in the slide, I was able to get from the available source where there is a international centers for the playing of video games. This example I have taken from the state of Poland and European countries and the USA. So people are very desperate, or people are becoming almost all addicted towards the game. Even when two people walk nowadays, they always look into the mobiles, they always look into the game. So therefore, this is another industry which has becoming as economic activity, creating huge revenue with regard to the video games are concerned and IP employment. Then this is also which you talk about the subsidiary development of video game. Like for example, consoles, PCs, mobiles, browsers, hardware, digital sets, then electronic sports, etc., etc., becoming as another product of the IPR. So therefore, the more and more you create the product, the more and more you have the different hardwares. Now, if you go to the gym, or there are a lot of shops which are providing about the sports and industry, and we have the computers. Computers is necessary for the playing of the game. So therefore, in international scenario, and we are all part and parcel of the system, and it is also promoting the business, and we are learning how to cope up with the international system. Now I'm coming to the India. So far I have gone to the some of the data outside country. Now I thought of discussing what there in India. And this is the one of the model of GPU. So basically GPU stands with regard to the graphical product unit. We have in mobiles, we have in laptops and everywhere. Let us see that how India has increased these models. Without graphics, there is no life. So, Indian employment in IP, apart from the traditional IPs, there is another sector which has significantly has taken on indigenous capabilities. Like IITs or the people who knows the electronics, they are coming with regard to the 34,000 GPUs and three more startups are going to come as Indian models. So India is known for its own foundation model and also is creating lot of employability with regard to the graphics product units. Then other one, SEBI law is also talks about DigiLocker and Digi public infrastructure. Now we have ONOS library, digital university, markets are going to be digital. So you have a digital infrastructure. Basically, this is what the SC Rice was telling. There was a law with the public infrastructure. Now we are going to the digital infrastructure is very important for Indian markets where we have to protect assets. One is the financial assets, we have the digital assets, and also comes about the IP rights. Then moving to the recent one which I found from the government of India, using of technology for exploration and exploitation of minerals. So in the March 18, 2025, Government of India, they conducted the hackathon is one of the most targeted industry in the world. If you go to any airport, any railway station, any functions, any parties in a home, people require a toy. Every toy has a mission and it requires automated mission. That mission need to be protected where the government is promoting to establish the promotion of industries of the toys and business of the indigenous toy industry in India. Then Digi services, and this I can take one example for all of us. No need to go anywhere. A single point of contact, either incorporation of business or doing of investments. So there is one place where all businesses are given. This is also promoted by Government of India, and the ease of doing a business, incorporation of companies like the Aadhaar number. Then you have the large number of products. So they provide the different processes they put into the digital sector. When you put in the digital electronic protection of, let us say, for example, circuits are being protected under the patents. So where you have the circuits and industries, designs, so many laws are being involved. Instead of the going, I'm going to the specific legislation, I'm putting as a digital innovation, creating an asset, and this asset is going to create an employability and also give for the revenue for a state and promotion of the business. And coming back to the last slide of today, my discussion, now, this is what given by the
Mr.
government
Milan,
of India
unmute us.
in the time
Take
of
the device.
innovation, in the area of digital world, man from the cradle to the grave, we require digital identity. So therefore, none of us are being away from their mind, etc., or the creativity. So therefore, an unbroken, lifelong digital identity is dead, either eternal verification or cornerstone of virtual existence. People are going to the Mars, people are going to the space, we are being identified with the chips, not the like electronic devices. This is what is happening in 2025, the line. And when we are looking for the 2047 Vikasit Bharat, so there may be some new world and new life. So to conclude in a positive note in this particular platform, that there is no doubt intellectual property rights are in the progressive of creation of employability and also creation of business and contributing a lot for the Indian economic development in addition to this and also international development of economy. Here just I'm pausing my lecture or my presentation because I just came here to share some of my thoughts without repetition of previous speakers. So I'm extremely thankful for organizers for giving me this opportunity to share some of my thoughts on this international webinar. And also a thank to all participants who are patiently listening almost all in the 5 to 5:40, 30 minutes of my presentation. Thank you one and all for listening very patiently.
Thank you, sir. Thank you so much for your unique and enriching speech on this topic. We conclude with this. I request the host team, Ms. Sarah Benjamin, to deliver the vote of thanks for today's program.
Good evening to one and all present here. It is both an honor and a privilege to deliver the vote of thanks at the conclusion of this enriching international webinar on the role of intellectual property in employment generation organized by the Department of Studies and Law, University of Mysore. At the very outset, I extend our deepest gratitude to our chief patron, Professor Dr. Loknath NK, Honorable Vice Chancellor of the University of Mysore, and our patron, Srimati M.K. Savita, KS, Registrar, University of Mysore, in their absence. Their constant encouragement, academic leadership, and institutional support have been instrumental in the successful conduct of this international webinar. A heartfelt thanks to our chief guest, Advocate Sri Vikrant Rana, advocate on record at the Supreme Court of India and managing partner at SS Rana and Company, New Delhi, for his illuminating address that bridged the legal and practical dimensions of intellectual property law with employment generation. We are also deeply grateful to our guest of honor, Dr. G.R. Raghavendra, Senior Consultant and former Joint Secretary at DPIIT, Ministry of Commerce and Industry, Government of India, for sharing his valuable insights and
Mr. Milan,
experiences from the
quickly
policy
unmute
making
so that
front.
I will talk about
Our
this
sincere
episode.
appreciation goes to our keynote speaker, Professor Dr. Srinivasalu NS, Professor of Law at National University of Juridical Sciences, Kolkata, for his scholarly presentation that set the tone for today's deliberations. We also thank our distinguished speakers, Professor Dr. Subhash Chandra Roy of Chanakya National Law University, Patna, and Professor Dr. J. Kondaya of Maharashtra National Law University, Aurangabad. whose academic contributions added rich perspectives to the discourse on IPR and its employment potential. A special note of gratitude to Professor Dr. M.S. Benjamin, Dean, Faculty of Law, and Chairman, Department of Studies in Law, for his visionary leadership as the organizing secretary. And to Mr. Syed Kudrat Hashmi, PhD scholar and coordinator of this webinar, for his tireless effort in planning and executing this event with great precision. Most importantly, we extend our sincere appreciation to the entire technical team for ensuring smooth